Welcome to the Las Vegas Review-Journal Judicial Primary Debates. Here's your host, Victor Jakes.
Hello, I'm Victor Jakes. Welcome to the Las Vegas Review-Journal's Nevada Judicial Debate Series. Today's debate is between two of the three candidates running for Clark County Family Court Department Y. They are Stephanie Charter and Karianne. Molnar. Rika Andrade wasn't able to join us. This is a new seat, so there isn't an incumbent. We'll start by giving each candidate 1 minute to make an opening statement. Stephanie, go ahead.
Yes, I am Stephanie Charter. I'm running for family court judge. I'm running for one of the 6 new judicial seats, and I'm running based upon my 29 years of legal experience, which includes serving as one of the first children's attorneys in Clark County for legal aid. I started there 20 years ago, and I worked there for several years, and then I went on to be a deputy district attorney in Clark and Washoe counties. And then in addition to that, my personal experience includes being the mom to 3 kids, married for 28 years, but also our middle child, my husband and I were blessed to bring home from an orphanage in India when she was 6 years old. She had lived in that orphanage for the first 6 years of her life. So as a result, she suffered from some challenges related to growing up in extreme poverty during her formative years. So I do have personal experience with what many of the children in child welfare go through. And it's my goal to bring all of this experience, my personal experience and my work experience, to the bench to serve all of the constituents in Clark County. Thank you.
Thank you, Stephanie. Carrie, you've got 1 minute.
My name is Karianne Molnar, and I'm also running for Family Court Judge in Department Y. I have been practicing for 15 years, 13 years have been in Clark County, and I have a wide background in family court. I have done every area of family court, and I've represented people through the appellate court, the Supreme Court, every level. I've also represented people in outlying areas in Nevada. So I believe that the experience that I have overall in family court is what is going to help me do the job to find out what is in the best interest of people's children and make those decisions for them, and the reason I'm most qualified to handle this position.
Thank you, Carrie. Stephanie, you'll get our first question. Divorces are a big part of family court and frequently involve emotional disputes. Will you tell us why you're the person best prepared to bring these conflicts to as peaceable a resolution as possible?
You know, so having worked for 29 years and having seen the legal profession from many different angles, as a prosecutor, as a children's attorney, a legal aid attorney, as a plaintiff's attorney, as a defense attorney, I participated in so many arbitrations and mediations and alternative dispute resolution type activities that I know what it takes to bring matters to a peaceful resolution. I know that particularly in custody matters, children's best interests are at the core of that. And as a longtime children's attorney, and currently I'm also a volunteer children's attorney through legal aid, I fully understand the best interests of children and what it takes to be sure that their interests are heard and kept at the forefront in those difficult custody battles. So I think judicial temperament plays a big part in those cases and bring those cases to a resolution. Being sure that everyone feels understood and heard helps to bring those cases to a successful resolution. And I would employ all of those skills in trying to resolve those cases.
Thank you, Stephanie. Carrie, same question for you. Why are you the best person prepared to bring the conflicts involved in divorce to peaceable resolutions?
Well, I worked, the 15 years has been in both divorces and custody cases, which many of those cases have been very high conflict. And so what we've had to do is many of those cases have went through settlements. A lot of my career has been in resolving cases, my own clients' cases, as well as I have been a mediator in private mediation where I've had many people call and ask to have me assist them with their cases. So I'm very used to that. Again, I have a very even temperament, and I've seen people in the court, different judges and how they deal with things. And I'm trying to take my perspective to become a family court judge is to take the temperaments that are best suited to bring those people to a lower level of conflict and move forward that way.
Thank you, Carrie. And Carrie, we'll start with you for this question. Is it more important for a judge to enter the courtroom ready to make a decision, which speeds things along, or should they be open to persuasion during oral arguments, which can cause a delay in issuing a judgment?
No, I feel that part of what I want to do is make changes to how certain courtrooms are ran. I believe that people need to have timely decisions when it comes to divorce and custody cases. And I feel that many times when people have to make a lot of oral argument, it's not when they're prepared, either attorneys or litigants, and they don't give the judge enough upfront with their motions and what they provide. As a family court judge, I think the judge should always read through the papers, look at everything on their own, and be prepared to make a decision during the hearing. As far as you have to look at everything involved, though, to determine what's in the best interest of the children.
Thank you, Carrie. Stephanie, same question for you. If you're elected, what's the balance between the what's written and what's presented orally?
Particularly in child welfare cases, I think that sometimes there's just been a swift change in circumstances. So I think in that instance, we would need to have some oral argument, at least some update from the parties, indicating what that change in circumstances has been regarding the child, regarding the parent, the foster parent, et cetera. So I think sometimes the parties and the attorneys do have to educate the court a little bit more than what's presented in the papers. And particularly in child welfare cases, I think oftentimes there are not a lot of pleadings filed. So in that instance, it's critically important to listen to what is presented in the courtroom through oral argument. It's important, of course, to have an idea of what the case is about, the law as it is applied to the facts when you enter the courtroom. But I think it's also critically important to be open to learning new facts if they're presented by the attorneys when they appear in the courtroom.
Thank you, Stephanie. And our judicial primary debates will continue in just a moment.
All your listeners and followers, the best name of any podcast in the world is podcast.
Nobody's ever done it. Nobody's ever faked
Not that we
their
know
death.
of.
No.
When you work with Prince, you got to get used to the fact that he changes musicians like underwear. You know, like
Tom Brady. And Tom Brady, he's a quarterback in the Boston area.
I'm not sure who you're talking about.
Alexa, play my flash briefing.
Here's what's new in today's news.
Stay in the loop of the latest information in the Las Vegas Valley with the Las Vegas Review-Journal Flash Briefing. Every day, we will provide you with everything you need to know in news, business, weather, entertainment, and sports. Go to the Alexa app and search LVRJ News Briefing. Then say, Alexa, play my flash briefing to hear 3 minutes of the most important information in Las Vegas.
You're watching the judicial primary debate for Family Court Department Y. It's part of an ongoing series of debates produced by the Las Vegas Review-Journal to inform local voters about these races. Stephanie, we'll start with you. You previously talked about your experience working as a prosecutor in child welfare cases. If you are assigned to cases involving the foster care system, should birth parents be worried that you won't give them ample opportunities to earn back their parental rights?
The bulk of my experience in child welfare was really representing children. I did that for the longest period of time, and I was a prosecuting attorney for about 5 years out of my total 29-year career. So no, that is not an issue for me at all. And representing children, what I found is what is first and foremost in their minds and in their hearts is to go home. What they want to do is go home. They want to be reunified. And obviously there has to be a safe way to do that. We have to mitigate the circumstances that led to their removal. But always the court's mindset is always to prioritize reunification. So, and that means looking at the birth parent, looking at the safety risk, looking to see what we can implement and put into place to make it safe for that child to either remain in the home or for that child to return to the home. And really termination of parental rights is the last resort. And we have to have, it's a two-pronged test. We have to have best interest. We have to have parental fault. So it's a tough thing really to reach that level of termination of parental rights. So no, I would certainly be equal for the parents and the children.
Thank you, Stephanie. Carrie, on your website, you write that you are, quote, very aware of the changes that need to be made to create a more respectful environment to litigants, end quote. Will you tell us which judges aren't being respectful to litigants?
Well, I don't want to name any certain judges. Where I got that statement is based on my 15 years of experience. I have seen many different judges that have come through elections and served different time periods. The thing that I realized, and it's not necessarily just one or two of the judges in family court, but it seems that litigants are not always given a fair opportunity to be heard. That's some change that I want to make in family court. Additionally, I believe that you have to have a very good temperament to be on the bench, and you have to make sure that people understand that they're going to be given the chance, such as if they don't comply with an order, or if they're going to always be given that chance at the next hearing. So I don't want to, again, name any particular names, but there's certain days that you're in front of a judge and their temperament is down, they don't listen to people, and it just appears to the litigants that they're not given a fair opportunity. They're not given the respect level that they deserve.
Thank you, Carrie. Stephanie, this next question will be for you, but you both have a chance to answer. Do you think any of your opponents lack the experience or temperament necessary to serve effectively as a family court judge?
You know, I don't have personal experience with either Carrie or with Mara Carr. I have, I think I probably know Carrie a little bit better than I know Mara Carr, but honestly, I have never appeared in court with either of them. I do know that the totality of my experience is 29 years, which is in far in excess of Ms. Andrade's experience and in excess of Carrie's experience. I cannot really judge their judicial temperament, having never been in court with either of them or seen, and I know Ms. Andrade occasionally serves as I've seen her on the bench. So I would not be in a position to judge that. I just can judge myself. And I know that I have 29 years experience as an attorney, as a legal aid attorney, as a prosecutor, as a defense attorney, a plaintiff's attorney. And so I know that I personally have the judicial temperament to serve on the bench.
Thank you, Stephanie. Carrie, same question for you. Are you concerned about either of your opponents either lacking the experience or having the right temperament necessary if they're elected?
As Stephanie stated, I don't personally know either candidate. I haven't had any cases with either of them. As Stephanie stated throughout this interview, most of her experience has been focused in the area of child welfare and abuse and neglect cases, which I've been appointed on the parent side as a defendant's attorney in those cases. But again, I believe that when you are taking the position as a family court judge, you don't know if your department is going to be an abuse neglect department or if it's going to be a department that handles all cases. So I think that my experience, although I may have been practicing less time than Stephanie, I believe that my experience with the wide, vast background that I have in every area of family court is actually more beneficial. And I can't discuss anything about Ms. Andrade because I don't know.
Thank you, Carrie. Carrie, this question is for you. You know, you guys have talked about experience versus the length of time you've been practicing. You know, I think for most voters, this just kind of sounds like a lot of a mumble jumble. When you personally evaluate judge candidates in different races, what do you look at? What are you looking for? And then tell voters how you meet your own criteria, basically.
I'm looking for how they run their courtroom. When you walk in, are you shown a level of respect? Because if you're not showing a level of respect to that litigant, you should not expect them to have to respect you. So that's one thing that I intend to do when I'm running the courtroom. The other thing that I'll intend to do is timeliness in having hearings heard when they're scheduled. Many times litigants have to sit and wait for hours to have a hearing held. They're taking time off work. It's affecting them negatively. The other thing is, we earlier discussed a little bit on decisions and timeliness of decisions. There are times when you don't get a decision on your custody or divorce action for maybe days. I believe that when a hearing is held, a decision should be made immediately at that hearing. And if there's services and things that need to be done, have those services ordered. But trials, you should not have to wait 6 months to a year to get a trial decision. So those are the big issues that I would like to change in the family court.
Thank you, Carrie. Stephanie, same question for you. If there's a position that's open, there's not an incumbent running, what are you looking for to select when you try and find a judge to vote for?
You know, I look for judicial temperament, which is really based upon how one conducts himself inside and outside of the courtroom, whether they're professional, for example, like in their Facebook posts, in their judicial page. You know, a level of professionalism is extremely critical for a judge, both inside and outside the courtroom. I look for community service. I look to see whether someone has reached out beyond their work to serve the community, and that's something that I have tried to do throughout my career. Long time ago, I served as the chairperson of the Community Service Committee for the Clark County Bar Association. I've long been a supporter of the truancy diversion program. I started under that with Judge Gerald Hardcastle and continued with Judge Elliott when they headed that program. And in addition, I've long been a volunteer with Legal Aid Center of Southern Nevada. So I look for volunteerism, judicial temperament, and of course experience, because experience does matter. There simply is no substitute for experience. You can't fake it. You only learn it by doing it the hard way, which is by going through the actual work.
Thank you, Stephanie. Stay tuned. This debate will continue right after these messages.
The Vegas Nation podcast is your source for all of your Las Vegas Raiders news. Subscribe and get fast takes and smart coverage. Download the Vegas Nation app and check out vegasnation.com to stay up to date with your Las Vegas Raiders.
For all your Raiders news, like us on Facebook, download the Vegas Nation app, and go to vegasnation.com.
Welcome back. Thank you for joining us. You're watching the judicial primary debate for Department Y. Stephanie, this question is for you. As has been referenced, Clark County is going to have 3 new judges working on child abuse and neglect cases, which is basically the foster care system. Acknowledging that every case is different and assuming you would be assigned to one of these roles, how much time would you give a birth parent who took only inconsistent and sporadic steps to work their case plan and attend visitation before terminating parental rights?
Well, it's really the prosecuting attorney's job to file that petition to terminate parental rights. So they're really in the driver's seat in that regard. But there's state law and there's federal mandates regarding getting to permanency. And generally speaking, we have the 6-month review where we take a look and see how well that parent is doing and if they're doing anything towards reunifying with their child. We have the 12-month review, and at that point in time, we have to adopt a permanency plan. And the permanency plan has to be termination of parental rights if, for example, that parent has only provided token efforts to reunify with their child. In fact, it's one of the parental fault categories. If the child has been in care for 14 out of the last 20 consecutive months, then that is presumed parental fault, which is presumed token efforts, which is one of the categories of parental fault. So we have to look at it from a time point for the child, because the goal for the child is always to get that child to permanency. From the beginning, we need to do concurrent planning and work towards permanency.
Thank you.
And if we're not going to get there because of token efforts, then we do have to move to termination.
Thank you, Stephanie. Carrie, same question for you. How much time would you give a birth parent who's taken only inconsistent and sporadic steps to work their case plan and get their child back?
Well, Stephanie said there's certain statutes and guidelines that have to be followed, as there are in every area of the law. And there's time limits for a party to get that child back into their custody. As an attorney for the parent side, there are some parents that do nothing to try and work a case plan or to do anything. And if their efforts are not there and they're not making the necessary efforts that they need to, I believe that at that 12-month review period, that it would be suitable to then move forward to terminate their rights. However, if you have parents that are working their case plan and making the efforts to get reunified with the children, then I think that there are times when the court does not have to immediately go towards termination. They can put that as a secondary goal, the first staying as reunification or possibly a guardianship. People can also relinquish rights. So termination is not the end all or the be all.
Thank you, Carrie. Carrie, we'll start with you on this question. Family court judges usually deal with people on some of their worst days. What in your background has prepared you to hear people fairly, even if they're not presenting the best version of themselves?
Throughout my last 15 years of doing family court, I always tell people when they come in my office, I wish I could meet you under different circumstances. Family court is a horrible time for litigants. They lose everything. You're losing a spouse, you're losing possibly a child or being threatened to lose a child, you're losing friends, you're losing financial stability. So I don't believe that the entire time that somebody's involved in the family court system, there's really ever a good day. It's hard. The decisions that come out of there affect families for the rest of their lives. So basically what I've always told people is stay calm, stay collected. There's temporary orders that can be put into place. It doesn't mean those are the final orders. Right now, with the way the statute is, the preference is to keep everybody with joint physical custody of their children. So as long as you're getting services, if you have issues, that doesn't need to be broken. Maximum time with children can be happening regardless. So I think that people just need to breathe and take it slow and just go through the process.
Thank you, Carrie. Stephanie, same question for you. You know, how are you going to treat people even though they may not be the best version of themselves?
You know, I would really draw upon my experience as a legal aid attorney, because I feel like at my core, that's what I really am, is, you know, that's where my passion and heart lies, is with legal aid. You know, and people who are in need of legal aid, including children in the abuse and neglect system, are frustrated, they're annoyed, they're scared, they have no idea what's coming next. So I think, you know, the skills that I employed in zealously and passionately representing children all those years at legal aid, I would do also on the bench. Everyone needs to feel like they've been heard. Everyone needs to feel like they've been understood, including the children in child welfare cases and including the children in custody cases through the mediation center who can interview children. So everyone needs to have a stake in the game and know that their voice is being heard first and foremost. And in addition, I think patience, right? You have to have patience when you're on the bench. It's tiring, it's difficult, it can be extremely you know, hard to be able to listen to people's stories, but they have to be able to tell their story. Otherwise, they're never going to have any sense of satisfaction with the outcome.
Thank you, Stephanie. And we'll be back with our final segment in just a moment. Welcome back, and thank you for joining us. You are watching the judicial primary debate for Department Y. We're a little short on time, so I've got 20 seconds for this question. Stephanie, we'll start with you. If you're elected, what do you want your legacy to be?
You know, really want my legacy to be the judge who did more. You know, I would model myself after judges who not only do their job and do it very, very well from the bench, but also judges that give back. I'm thinking of Judge Sullivan, who always is so entwined with CASA and giving back to CASA. Judge Elliott, who championed the truancy diversion program. That is what I would want my legacy to be not only the judge, but the judge that gave back.
Thank you, Stephanie. Carrie, same thing. If you're elected, how do you want people to remember you?
I want them to remember me as a judge that the first priority is going to be the best interest of children. As long as the children are safe and protected, I feel that that is the main goal of family court. I also want people to be heard, to have a fair opportunity, and to know that they're heard and that they matter.
Thank you, Carrie. We're going to move now to closing statements. These will be 30 seconds, and Carrie, we'll start with you.
In closing, again, I am running. My goal in this is to make sure at all costs that children are safe and protected and that their best interest is met. My goal is also to make sure that parents' time is maximized with their children. So regardless of whether they have any issues, they can get services, but that time with those children will not be taken away from them. Again, as I stated, I have been practicing in every area of family court for the last 15 years, and I have experience in the abuse and neglect section. I have experience with the diversionary court, the truancy program. I was a judge in the school system. And so I'm just asking for people's support and vote during this campaign.
Thank you, Carrie. Stephanie, 30 seconds.
Thank you again, Review Journal, for this opportunity. It would be my true honor to serve as a judge for this community in Department Y. I would bring the totality of my life and work experience to benefit everyone in Clark County who appears in Department Y. And why does experience matter? It matters because it brings with it understanding, it brings with it integrity, it brings with it knowledge of the law, That's why experience matters. I have that experience, and that is why I'm running for family court judge department-wide. I appreciate your support, and to learn more, you may go to www.charterforjudge.com.
Thank you, Stephanie. And thank you both for joining us. And thank you for watching this edition of Nevada Judicial Debates. We'll see you next time.